Hello, everybody. Today, I say today, but whenever you're watching this, but this is the case law on disability discrimination that I have found. So AB versus the governing body of Kingston Grammar School 2024. This disability discrimination case makes clear that in most instances, parents must demonstrate that their child meets the definition of disability under the Equality Act 2010. While diagnostic evidence may assist, parents are still required to evidence each element of the statutory definition, unless the child has a condition that is automatically treated as a disability under the Act. The case also clarifies how the Centre Tribunal should handle claims and appeals, whether under the Equality Act 2010 or the Children's and Families Act 2014. In most cases, the Centre Tribunal should hold an oral hearing addressing all issues in dispute before reaching a decision, unless all parties in the tribunal agree that the matter can be determined on the papers. If a party does not attend a hearing, the tribunal must either proceed in that party's absence or adjourn and rearrange the hearing. Once a hearing has begun and a party is known to be absent, the tribunal cannot switch to determining the case on the papers instead of continuing with the hearing. So basically what this is saying is that it's down to the parent to prove that the child has what's met under Equality Act 2010's definition of disability. It also clears up how a hearing should be, who should be attend, whether, when and where a paper hearing can be done. RD and GD versus the proprietor of Horizon Primary Responsible Body 2020. So this one is whether a part-time table is discriminatory depends on whether it represents a proportionate means of achieving a legitimate aim. The school must weigh the disadvantages to the child against its intended objective and assess whether those disadvantages are justified. In this case, the part-time table was found to be proportionate and therefore did not amount to discrimination. So what it's saying here basically is that a part-time table in the best interest of the child? Is it for the support the child in the what are the reasons behind a part-time timetable? We can't just say ultimately that we have the blanket policy to say that part-time timetables are fully lawful, because sometimes it's in the best interest and support the child's needs and why we need that part-time timetable. UW versus Cheam Academies Network 2026. So the upper tribunal held that under paragraph 2(4) of Schedule 13 to the Equality Act 2010, the duty to make reasonable adjustments under Section 20 applies to schools in relation to both admissions decisions and the provision of education or access to benefits, facilities or services. This latter duty includes the implementation and application of a school's behaviour policy, including sanctions and exclusion. The first-tier tribunal was therefore wrong to conclude that it lacked jurisdiction to consider a reasonable adjustments claim in relation to the behavioural policy, including issues such as detentions and exclusions. So what it's saying here is that basically, under the Equality Act 2010, paragraph 2(4), Schedule 13, it states that reasonable adjustments apply to schools and they must make reasonable adjustments around behavioural policies, and that includes whether detentions and exclusions are appropriate.